Hi everyone. Today's topic is about the rules, members, and directors inside a company. This includes what rules govern a company, who makes decisions for the company, and how the company makes decisions. This presentation will go through some background information to make sure you have a good understanding of the content on the following slides. We will tell you what we believed the main issue was, as well as the subsequent sub-issues that helped answer the main issue. We will provide our opinion on the conclusion of our results. We will then finish off with any questions you may have. I must also mention there will be surprise quizzes throughout the presentation, so make sure you're paying attention. This presentation will talk a lot about members. A member of a company is any person with the legal capacity to own property, whether it's an individual or corporation. A member of a company is often called a shareholder. Before July 1998, a company was required to have a Memorandum of Association, which is an external document that sets out important details of a company, as well as an Article of Association, which is an internal document that specifies the regulations for a company's operations and defines the company's purpose. The Company Law Review Act 1998, as part of the effort to simplify and modernize company law, amended the legislation to convert all existing memoranda and articles into a single document called the Corporate Constitution. The effect of the Corporate Constitution as a binding contractual document is significant because the Constitution sets out the distribution of powers between the members, directors, and the company. Under Section 134 of the Corporations Act, a company may decide to have its internal management governed by a corporate constitution, replaceable rules, or a mix of both. However, a company listed on the ASX must not rely solely on replaceable rules. Replaceable rules are defined as statutory provisions dealing with internal management, located in the Corporations Act. If a company chooses not to create its own constitution, Section 135 sets out the default rule that the replaceable rules will be used to govern the company. The overarching issue for today's question is, what legal rights can we advise shareholders and activists regarding their involvement in Brief Limited? Our goal is to draw conclusions regarding the rights of these specific shareholders. We will take you through 3 different sub-issues. The first one being, is the SNAP members meeting a valid meeting? 2 is, can the outcome of the meeting be challenged by members? And lastly, were the alterations to the company constitution valid? There are various assumptions that need to be made for this question. These include assuming that In Brief Ltd have a company constitution as opposed to replaceable rules, assuming the diverse group of shareholders includes minority shareholders, and lastly, assuming the members did not agree to be bound by the company in writing. We will touch on this later in the presentation.
The first sub-issue we are going to talk about asks the question, is the SNAP members meeting a valid meeting? To answer the question of the validity of the meeting, we assume that the company is using a company constitution. Section 249 covers the grounds on which a members meeting is valid. The relevant sections used to answer this issue are sections 249HA, 249J, 249L, 249R, 249T, and 250S. The case that has also been used is Smith v. Sattler. When convening a meeting, there are various requirements that need to be met for it to be valid. Adequate timing of notice must be given under Section 249HA, which sets the minimum to be 28 days notice for an ASX-listed company, which is not adhered to by In Brief Limited, who only gave a 14-day notice. All members require prior notice to be given and to allow the opportunity for participants at the meeting who are eligible to vote to be able to put forward a motion. Notice of a meeting must be given to voting members and directors under Section 249J. Section 249R states that the time and location that the meeting is held in is reasonable and accessible to members, and this requirement is not met as the meeting was conducted in Perth instead of their usual place in Sydney. This is similar to the case of Smith v. Sadler, where the directors knew members would not have a fair chance to attend. The directors must provide sufficient information for the members to know what is proposed to be decided at the meeting. Under Section 249L, the exact words of the change to the Constitution have not been provided in the notice of the meeting. As it states, notice of the meeting does not contain the information booklet nor the purpose of the meeting. Although there are no requirements to let members speak in a meeting other than an annual general meeting, the chair is acting in bad faith by not even giving members of the shareholder group a chance to speak. Therefore, the meeting was not valid under Section 249.
The second sub-issue is, can the outcome of the meeting be challenged by the members? Following on from the above issue, we concluded that the members' meeting was invalid. However, this begs the question, do we have to start all over again? The answer is no. Despite all of these procedural irregularities under Section 249, Section 1322 can be used to give the court the power to validate an invalid meeting. The relevant sections to answer this issue includes Section 1322 subsection 2 and subsection 3, and Section 232 of the Corporations Act. The court can rule in favour of validating the meeting if a meeting is not invalidated, merely because of accidental omission of notice given for the members' meeting. However, the court can rule the meeting to be invalid under Section 1322 subsection 3A if, for example, a member does not have a reasonable opportunity to participate in the meeting or a proceeding at the meeting. On that ground, that substantial injustice has been caused. Injustice is being experienced in this question as the board undertakes this action to ensure the attendance is low, and the chairman refuses to allow any of the members from the shareholder group to speak. Therefore, members may challenge the validity of a meeting where management is being unfairly oppressive, prejudicial, and discriminatory against their interests under Section 232. There are also equitable limitations surrounding the majority voting power, as the chairman limits the opinions of the shareholders. As a result, Section 1322 should not be enforced, rendering this meeting to be an invalid meeting.
The sub-issue identified is whether the alterations to the company constitution were executed validly at the SNAP members meeting. For this question, sections 136 part 2, 232 to 234, 140 part 2, and section 249Y have been used. The important case relating to the change in the constitution in Gambotto vs. WCP Limited. In any problem question involving the change in the constitution, we look at the Corporations Act to see if the change can be made or are there statutory or general law protections surrounding what is proposed. Section 136 part 2 shows that the company may modify or repeal its constitution or a provision of its constitution by special resolution. Special resolution is a resolution passed by at least 75% of the votes cast by the members at the meeting, not of the total number of members. We can conclude that the resolution was validly passed by a majority 75%, and the voting procedure was correctly followed. Being a member gives rise to a number of basic legal rights under both the Corporations Act and the company's constitution. Common law rights of members include the right to enforce statutory contract, the right to attend and vote at a members meeting, and the right to receive information about a company, including info relating to the proposed members meetings, which have not been adhered to by InBrief Limited. The ASX also requires listed companies to receive membership approval where the company proposes to make a significant change to its trading activities, such as a 12-month suspension of dividends. Section 140, Part 2 states that unless a member of the company agrees in writing to be bound, They are not bound by any modification of the Constitution made after the date on which they became a member so far as a modification. This means members are not bound to have their dividends suspended, assuming it's not written. Also, the use of undirected proxy severely diminishes the shareholders' ability to pass any resolution put forward by them. The relevant rule to this issue is under 249Y, subsection 3 of the Corporations Act 2001, named Right of Proxies. The rule states that the presence of the company's members in a meeting has an effect on the authority of the proxy. This rule is applied to this situation due to the CEO using undirected proxies in order to push through unfavourable alterations despite members being present. Furthermore, assuming of the 60 shareholders who are wanting to convene a members' meeting are minority shareholders, statutory protection in sections 232 to 234 limits freedom to alter constitution. Shareholders can apply for an order under this same section as the actions of In Brief Limited are oppressive, unfairly prejudicial and discriminatory, as well as operate against the interests of the company as a whole. This is experienced as In Brief Limited omitted requests to information booklets. If the change to the Constitution involves amending a corporate constitution, we need to then look at Gambotto's two-stage test. Firstly, the change is not for a proper purpose, like preventing harm to the company, instead of used to fund internal expansion. Secondly, the change is not fair in the circumstances. To conclude, these changes to the Constitution were invalidly executed by the members' meeting because his undirected proxies didn't have the authority to make such alterations to it due to the members being present. Furthermore, although the alteration of the Constitution was passed by a special majority of shareholders present at the meeting, the passing is not valid as the company treated shareholders with injustice and oppression.
To summarize the conclusion to the main issue, the rights of the shareholders are their ability to challenge the validity of the alterations and the meeting itself. It then can lead to challenging the outcome of the meeting.
Overall conclusion is to summarize the conclusion to the main issues is the shareholders have the right to challenge the validity of the meeting. Besides, it also can make different results of the meeting. So thanks for the watching. This is our presentation. If anyone have something mistakes or something misunderstand, please feel free to ask us questions about the issue. Also, we will have a final quiz for everyone. Thank you.